Recording in progress.
Okay. So, okay. Okay, good afternoon, guys. Welcome back to the lecture of CA Inter Paper 2 Corporate and Other Laws. So, yesterday we understood about Companies Act basic things. Then we understood what is a company. Then we understood Companies Act is applicable to which all entities, to which extent. Now, I can be reassured that yes, you know what is a company. But let us understand some disclaimer before going ahead, okay, to these things. Let's see. Guys, if you open your module, in your module, the first lesson is called as preliminary. Okay, so I'll write that preliminary here. Preliminary. We'll also start in the very same way. But in preliminary, what is given, you know, it is all definitions are given. And for your exams, all definitions are not useful, but yes, 50 to 60% are useful. But how I have or we have drafted the note that we have not put the definition at one place and I'll be explaining you all the definitions. No, because I know in human psychology we tend to forget the definitions. So what we have done, okay, we have started the topic in a different way, where all the basics will be covered, and where and when the definition is required, at that time I'll be telling you. So this is how we have started it. So see, preliminary topic we have divided into three parts. First part is introduction to company. In introduction to company, we study three things. First is definition of company, which I think we have done yesterday. Next, we study features of company, which will be starting now today. And one concept called as lifting of corporate wheel. Lifting of corporate wheel. Corporate wheel. These are the three things which will be there. Second point is classification of company. Hell lot important for you people. Hell lot important. Classification of company. And third, a concept of conversion of companies. Conversion of companies. Okay. Now conversion of companies means how to convert public company into private company, private company to public company, and there is a concept of one person company to normal companies, and normal companies to one person company. These are the things in conversion. Now I'll tell you, I'll give you a disclaimer. This part, apart from the definition is obviously there in your syllabus, but apart from definition, this part, introduction to company law, features and lifting of corporate will, is actually not in your syllabus. So you'll not find it wherever you see the module and all. It is not there. So why we are teaching you this thing first? Because we have two sets of students now. One set of students which have done which are from foundation route, and one set of students which are from the direct entry route. Now these two things, before your CA Inter there was IPCC. In IPCC it was there in Inter part, but this same part is there in foundation. So what institute tells, why institute has not added this in Inter? Because they tell you we have two sets of students, as I told. First is foundation route. So they have studied all this thing in foundation and they remember everything. Just imagine how much ICAI trusts you. We know now how we have studied. And second, direct entry students have also studied this thing in their college and they remember everything properly. So much of confidence. You'll be like, so that much confidence we don't have on ourselves. Yes or no? So why should we make our students run everything again? So they have not kept it. But we know how we have studied. And that's the reason we have kept all these things in our books again. So that you can understand the concept. See, if the roots are not strong, obviously how can we make a big building out of that? And that's the reason we are again teaching you all these things again. But yes, again remind you, this is not there in your syllabus. But without studying this thing, obviously, we can't understand companies act also properly. So we are again studying all this thing. This is there in your syllabus. Okay, this is actually your CA inter syllabus. Okay, understood? Now we have studied definition. So now we have to study features of company, or you can say characteristics of company. See, when you know what is a company, but in order to better understand a company, you need to know the features. Like if you know, if you're about to get married, you know this is the person, but in order to better know the person, you need to know his likes, dislikes, his character, or yes or no. And that's the reason we are studying company's features also. Okay, and I'll be putting some questions here. Even though it is not in your syllabus, I'll be putting some questions so as to show you what is the level of CA inter. This is how questions will be coming. I always say CA inter and CA final is not about writing answers. It is about cracking the questions. Once you crack the questions, you'll clear the exams. Am I clear? Let's start. Okay. Let's start with the features. Features of company. Features you can say, or you can say characteristics. Because when I teach, I assume that you don't know anything. That your assumption is very correct. So chalo, let's understand the features. First feature of the company, is corporate personality. Corporate personality. Now what is corporate personality? Corporate personality, sir, have you heard this word corporate personality? You'll be like, no sir. Arey, but I am telling you, you know this word. What is corporate personality? You know, separate legal entity. A company has separate legal identity. Like, let's take an example. Example, I have 1 crore rupees. Example, I am very poor person. Example, I have 1 crore rupees. I formed a company. I put the entire 1 crore rupees in the company. Indirectly, can I say I hold the entire share capital of the company? I purchase entire shares of the company. But even though I hold the entire share capital of the company, me and the company are same persons or different persons in the eyes of law? Different persons. If there is a song, you know, same but different, no money. Correct. We know the songs properly. So what is this point? Okay. This point is the person forming the company and the company are same persons or different person? Different persons in the eyes of law. They are different. Am I clear? And it is applicable to us also. I'll give a general example. Like when we were born, before we were born, we are a part of our mother. Yes or no? But the moment we are born, we are a separate legal person in the eyes of law. That's the reason we have separate Aadhaar card, separate PAN card from our parents. Is anyone in your mom's Aadhaar card like this? No, obviously not. Okay? We are separate. That's the reason we have separate Aadhaar card, PAN card, all other documents. Clear? Okay. Now the second one. Second is limited liability. Now what is limited liability? Let's understand. Okay. And after I explain, online students, I want quick answer from you. I have one question I'm going to ask you. The limited liability, this is the foremost reason why people started forming companies. Let's take an example. Example, I decided that I will quit teaching. Okay. and I'll start a tea business. So I started a tea business, and it's a sole proprietorship business. Small stall I have started. I'm very good in making tea. Now tell me and that sole proprietorship firm or business are same person or different person? Same person. So any debt taken by the business is my debt. If I don't pay that debt, or if the business fails to pay the debt, am I personally liable to the creditors or not? Yes, because me and my business are same person. But I'm a bit smart here. What I do now? I don't start a sole proprietorship. I start a company. CS Chai Wala Private Limited. Smart. That's why. Now what I did? I started a business in the name of company. Now tell me and company are same person or different person? Different persons. So any debt taken by me, by the company, is it my debt? No, it is company's. Okay, so in case the company doesn't pay the debt, can the creditor sue me? It is not my liability. My liability, I am not personally liable to the creditors. I don't have unlimited liability to the creditors. I have liability towards the company, and that also to a limited extent only. Now what is that limited extent? Let's understand. See, I am writing here. Then I'll give example of that also. So the liability of members is limited. Is what beta? Is limited. Limited up to what? Limited up to the unpaid. Up to the unpaid face value of shares. Unpaid face value of shares held by them. Held by them. Or up to guarantee given. Now this is red partner. I'll teach you later on, not now. I don't want to make khichdi of everything. I don't want to mix everything up. That's the reason. Guarantee given. Now let's take an example of this. Let's understand with an example. See the example. Example, I decided to form a company. And will you be my partner in the firm, guy? Yes. Not partner. Will you be a partner in the company? Yes. What's your name? Sumit. So see, Harsh and Sumit. We two people decided to start a company with the name C, and we are selling tea only. CACS. You know how to make tea? Yes, na? Or else you can sell biscuits, no problem. Okay. CACS Chai Wala Private Limited. Now to start this tea business, okay, we wanted some capital. Okay. So we decided how much capital we'll put. We decided, up till now we have not put. So we both decided we'll put 1 lakh rupees in the company. How much? 1 lakh. 1 lakh. 1 lakh. So if total is how much? 2 lakh. So 2 lakh rupees is the amount we have decided to put. So indirectly can I say we have decided to buy shares worth this much in the company? Yes. So we have put the money or we have decided? We have just decided, okay, we will buy this many shares or value of this many shares. So basically this is called as subscribed capital. What we call beta? Subscribed capital. This is the amount which we have decided to put. But now when we started our tea business, we understood we don't require 2 lakhs. We just require 50,000 rupees. One small stall and some utensils. That's it. Some branding advertisement. That's it. So we actually put in the company how much? 50,000. How much? 50,000. So individually how much we will pay? 25,000. 25,000. Correct? So this is the amount we have paid on the shares. So what is this? This is called as paid up capital. What is it called, beta? Paid up capital. Clear? So how much is the unpaid capital? 1,50,000. Individually how much? 75,000. 75,000. Correct? 1 point. Now we started making tea. We started selling tea. Day night we are making tea. We are selling tea. We are having tea. We are smelling like tea. Day night. But after 1 year, what was our asset valuation, after 1 year? We started with how much money? 50,000. After 1 year, our asset valuation was 1 crore rupees. Boss, we are doing business. We are doing religious business. One student came to see us. Or chalo, Mohit sir came to see us. And he told me, wow, what a business, man. Okay. There should not be any drishti. And his drishti only started. Negative drishtis. After that, nobody is buying anything from us. Day night we are going into losses. After my lecture, Mohit sir's lecture is there. Don't tell me, tell him this example. Okay. Now, so day night we are doing losses. Every day there is loss. So we decided we'll shut off the business. We'll close the company. But while closing up, can we just say wind up and go? No, there is a procedure. Na? We have to sell the asset, pay the debts. So we saw what is our debt. Our debts were 2 crore rupees. See, I told you yesterday, no knowledge is dangerous. Half knowledge is positively dangerous. So first what we'll do, we'll sell the assets. We sold the assets of 1 crore. Then 2, there is the debt. How much debt still left? 1 crore. Out of 1 crore, first how much we will pay? Our unpaid face value of shares. We have not paid this 75,000. Na? So we'll contribute. So that is total how much? 1.5 lakhs. Then to outstanding debts is how much beta? 98.5 lakhs. Now how much we will pay? Answer 0 rupees. Because this 98.5 lakh loss debt is our debt or company's debt? Company's debt. Our liability is limited up to the unpaid face value of shares we are held. Have we paid the unpaid face value of shares or not yet? Now we will not contribute a single rupee. That is the reason I told. This is the very reason people started forming companies in India and outside India. Limited liability. So people ask, sir, what happens of this? What happens to this 98.5 lakh? Answer very simple. Okay, just for your knowledge, in the company's account, it will go in deficiency account during winding up. Deficiency account. And for the creditors, it will go where? Very good. It will go into bad debts. Am I clear with this? I hope you are clear with this thing. Limited liability. The liability of member is limited up to the unpaid face value of shares held by. Am I clear? Yes. Everyone. Quickly tell me true or false. Or I said ask true. I'll share the notes, no problem. If you want to have running notes, you can do it. No problem. Okay. Now I am asking you true or false answer to this. The liability of company is unlimited. True or false? Liability of company is unlimited. True or false? True or false? Answer is true. The liability of company is unlimited. Liability of members of company is limited. Am I clear with this thing? Very good. Very good. Very good. True. False. True. Answer is true. Very good. I hope I am clear with this. Yes? Okay. So the 2 points we have covered. 2 features. Third feature is perpetual succession. What is the third feature? Perpetual succession. Sir, what is this perpetual succession? Acha guys, you know what is the meaning of perpetual? Yes, perpetual means continuous. Okay, or we can say forever. People say na, newly married people, my love for you is perpetual. That is continuous or forever. Okay, whether they mean it or not, I don't know. Afterwards we get the news, Meghalaya news, drum news, cement news. That is, let it be. Now So basically, what is perpetual succession? See, does anyone amongst you have perpetual succession here? No, obviously neither me, neither you, because we are naturally born. We have natural birth, so we'll definitely have natural death. But is a company born naturally? No. It exists only in the books of law. You might have heard, congrats, it's a baby boy. Congrats, it's a baby girl. Have you heard, congrats, it's a baby company? No, obviously not. And that's the reason, beta, we all have validity period. After that, we'll all expire. You become a CA, you don't become a CA. One day we'll die, but will a company die? No. Like the person who formed the company may die, but will the company die with him? Example, who formed Reliance Industries Limited? Sir Dhirubhai Ambani. He died, but did Reliance die with him? No. Am I clear? So for that, there is a tagline, that is, members may come and members may go. But company stays forever. Okay. Understood? Everyone? Clear? Okay. So three features we have finished. Okay. Now we'll start with the fourth feature. Okay. Let's start with the fourth feature. Fourth feature is transferability of shares. And after that, I'll give you some questions also. Transferability of shares. Guys, tell me, in a company there are shares. Yes. Can we sell the shares? If I have some shares, can I sell the shares? Yes, obviously. But, sir, there are two companies. You might have heard. We'll talk about this later also. Public company, private company. Tell me, shares of which company can be transferred, can be sold? Public or private or both? Answer is both. Shares in both the companies can be transferred, guys. Both the companies can be transferred. Some people tell ki sir only public company shares can be transferred. No. Private company share can also be transferred. It's quite logical. If I buy share, what is share for me? An investment. If I cannot sell my investment, will I anytime buy that investment? No. So shares in both the companies are transferable. But there is a but here. Now what is that but? The but is in public companies. Shares are freely transferable. Like I'll give you an example. Reliance Industries Limited is a public company. Now you can buy this public company which are listed companies. You buy and sell the shares through your mobile also, Zeroda app, Grow app and all, and it is freely transferable. Private company shares are also transferable, but subject to restrictions. Where will be the restrictions written? In the articles of association. I call it as AWA. What I call? AWA. Now sir, what restrictions would be there? It would be written like, in case I want to sell the shares, I have to first offer the shares to the directors of the company. They will buy it. If they don't buy it, then only I can sell to outside. Or before selling the shares, I have to take approval of board of directors. So restrictions will be there. Will there be prohibitions? There will be restrictions. Am I clear? So shares in both the companies are transferable. Okay. Public company freely transferable. Private company transferable, but subject to restrictions in the articles of association. I call it as AWA. What I call? AWA. And I don't pronounce it like AWA. I have a tone to tell it. Okay, my students might be knowing this thing. So I say like this: private company shares are transferable, but subject to restrictions in the AWA. What do we say? AWA. When you tomorrow MO will come, Memorandum of Association, another document. Okay, then we say MAUA. What do you say? MAUA. Am I clear with this thing? Understood? AWA and MAUA. So see, shares in both the companies are transferable. Public company, it is freely transferable. What is it, beta? Freely transferable. Private company, shares are also transferable, but subject to restrictions. Where will be the restrictions written? Articles of association, two important documents, AOA, MOA. So restrictions are written in the AUA, restrictions in the AUA. And when you study at that time, also study like this. Enjoy your studies. Now, so this is about the fourth point. Now the fifth one, very important, very important, very important for you people as chartered accountants. The next one is common seal. What is the next one? Common seal. Have you heard about this, online students? Common seal, common seal. Public. See, many people wrote public only. Okay, it is public and private both. Okay. Reliance Industries, how it is a public company, I'll tell you. Don't worry, I'll tell you everything. Public company, private company. Once we start classification, at that time, because when many of the graduates have this in mind, I think you also have, Jairam. A public company means government controlled and all. It is nothing to do with that. That is the reason I told you classification very important. Everything I'll tell you. Don't worry. Okay. Now common seal. Now what is common seal? If I ask people common seal, okay, so they give me one answer. What is that answer? Official signature of company. I'll write it, and now in common seal audit point will come. I'll prove you how audit comes into picture. That is official signature of company. Okay, that is common seal. Now tell me, if you are major, can you people enter into contract? Yes. Can I enter into contract? Yes. Can a company enter into contract? Answer is yes, companies do enter into contract. But if it is a written contract, can you people sign? Yes, na? If you can't sign, at least this though you can do. If can I sign? Answer is yes, I know I can sign. But can a company sign? Answer is no. Because company doesn't have hands, legs. Company doesn't have physical existence also. Has anybody seen a company? Has anybody seen a company up till date? Anyone online people, if you have seen a company, just let me know. Anyone seen a company? Anyone has seen physically a company? You might have seen better the office of company, factory of company, the premises of company. But where is company? Company does not exist physically. Company exists only in books of law. Am I clear with this thing? So, if the person does not exist, can he sign? No. But if it is a written contract and the person entering into contract is not signing, will it be a legal contract? No. So lawmakers told that there should be something to denote that the company has signed it. So what is that, beta? Common seal. Now how is a common seal affixed on paper? On contract, people say like this. No, it is not like this. This is rubber stamp. If we read company's incorporation rules, guys, it is written specifically, it is written common seal is not rubber stamp. How it is, how that rubber stamp is like you put it on the ink and then like stamp it. So that is rubber stamp. Common seal is different. Common seal, I'll tell you how it common seal is. How is the common seal? Like it's like a steel instrument like this. Here there is a steel plate and here there is a steel plate. And the name of the company is engraved on it. Engraved means it's pointed. No ink, nothing. If you want to put a common seal on any paper, put the paper here and there is a button here. You press it from it. And it is very tight. Once you remove the button, okay, then beta, the name of the company comes in a circular format on the paper. Like if I put a nail on a paper, how the impression will come? So the name, the impression will come like that. That is common seal. Just imagine beta, if your company has made a contract and your director tells ki just affix common seal will come and you put rubber stamp. Beta, the whole contract is void now. The reason is that beta you put common seal, you put what beta? Rubber stamp. An example beta, already stamp duty of 10,000 is paid on it. Now again you have to pay stamp duty. The whole contract is void. Did you understand? That is the importance. So sir, the common seal is a very important thing. Is common seal mandatory or optional? Answer, it is optional. It is not mandatory. Okay, why it is optional, that also I'll tell you. So as per Companies Amendment Act 2015, common seal is optional, not mandatory. Initially it was mandatory, but sir, then why it is optional now? It's such an important thing. I'll tell you the reason. See, like when lawmakers, like I told you, a drafting committee makes law. So there are some advisors, there are some committees like Naresh Chandra committee, JJ Irani committee and all. These are big committees. So these committees ask one question to the lawmakers. Why are you telling common seal is mandatory? That they told from years it is mandatory. So they ask one question. Who affixes common seal? Is there any person who affixes common seal, or common seal on his own walks and gets affixed? No. Who affixes? Director. Which director? Authorized director. Authorized means where, beta? He is authorized in the board meeting. There is a resolution passed. Resolve that Mr. X, the director of the company, is authorized to affix common seal on the paper. And only he can affix. And basically when he affixes the common seal, he also has to sign as a witness that I only have affixed. So ultimately then they ask that the director has to sign. Na? So common seal is just an instrument. So why are you making that instrument mandatory? And so after so many years they're like, correct. They are telling correct. So then beta, as per Companies Amendment Act, in the Amendment Act, common seal was made optional, that it is not mandatory now. But now sir, one problem comes. The problem is, sir, authentication of documents. Means who will sign on behalf of company? Sir, who will sign beyond? Because common seal is there, common seal will be there. But if common seal is not there, then who will sign? See, understand. So who will sign? Now, understand. So there are two things here. Sir, first, if company has common seal, has what? Common seal. Then very simple, affix common seal, no problem, affix common seal. Affix common seal. Affix common seal. But if company does not have common seal, then what to do, sir? If company does not have common seal, then what to do? Then you have to see one thing. Now what is that one thing? You have to see beta whether the company has whole-time company secretary, whether the company has appointed whole-time company secretary, whether the company has a company secretary. Okay. So basically company has whole-time company secretary, or company does not have I am writing for whole-time WTO, whole-time company secretary. Now if the company has whole-time company secretary, na, so who will sign on behalf of company? One director plus the company secretary. But in case company doesn't have company secretary, then who will sign? Two directors. Who will sign? Two directors. Which two directors? Any directors or authorized director? Authorized directors. One of whom shall be managing director, if any. Like if the company has managing director, then one of the directors should be managing director. Am I clear with this? Understood everyone? Clear? Now let's understand. Now if you go for audit, see where does audit come into picture? Like last year somebody else was signing on behalf of company. Now somebody else is signing. So what will you ask from the company during audit? Yes, board resolution authorizing the director, show me that. Am I clear with this? So that is where you'll check. Any other question? Because after that I'll start asking questions. Any other question? Online students, any other question? No? I'll ask a question. Sir, it is written company has whole-time CS, company does not have whole-time CS, correct? So sir, isn't appointing CS mandatory? Is appointing company secretary mandatory or optional? Answer, it is mandatory for certain companies, just for your knowledge. First, listed companies. Which companies? Listed companies. Second, unlisted companies having paid up share capital of 10 crores or more. How much? 10 crores or more. Have to mandatorily appoint company secretary. So you should know, see, you didn't even know whether your client is required to appoint CS or not. Just imagine if they are required to appoint CS, but 2 directors are signing and you are not putting any remarks because you don't know Companies Act. Example, in the annual general meeting, some member stood up and he's a chartered accountant and he asks you, who's the bloody auditor? Doesn't he know that the company has to appoint a CS? You have to answer to him in front of everyone now. That is the reason I told you, beta, boss, if you don't know Companies Act, can you be auditor? No, impossible. Am I clear with this? Understood? Okay. So this is common sense. So I am putting some questions. After that, we'll start with the other features. Okay, only 3 features are left, but let me start with some questions. My first question. Okay. We'll start with very simple question. A person can be a member as well as creditor of the company at the same time. True or false? True. Online students, tell me. True or false? True. Okay. True. Very good. True. Oh, all are true. Very good. Okay. True. Salmon versus salmon case. Very good. Answer is true. Correct. I'll give you why true. Take a understand. I'll tell you why. The reason is that, example, if I buy shares of the company, I become a member. An example, company issued debentures. You know debentures. If I buy debentures mean debt. I have given debt to the company. So I become the creditor. So at the same time, can I buy shares as well as debentures of the company or not? Yes. So at the same time, can I be member as well as creditor of the company? Answer is yes. Clear? This was a very simple one. Let's start with some technical. A second one, I think foundation people will give the answer because they had a case law on this. Okay. But direct entry also should understand the concept. Okay, and then answer. No, I'll take another question. Then I'll take the third question. Answer this. Absolute restriction clause for transfer of shares in AOA means articles of association of a private company is void. Void means invalid. True or false? You give this answer. True. Okay. False. Some people are telling false. True. False. Okay, true. Okay. Answer is true. Now why it is true? See, I'll explain the question. Absolute restriction means what? Absolute restriction means prohibition. Simple. Prohibition clause for transfer of shares in AOA of a private company is void. That means, beta, understand, this is my AOA of my company, my private company. In this, it is written, there is prohibition on transfer of share. That means the shares of this company cannot be transferred. Tell me, shares of a private company can be transferred or it cannot be transferred? Can be transferred. So this statement is correct or incorrect? Incorrect. Valid or void? Void. They have also written the same thing. Such statement is, answer is, make clear. Everyone online people, correct? Good. Third question. Acha. Before I give the third question, I will take the features. I hope beta you understood 5 features up till now. Okay, which 5 features we have finished? Corporate personality, limited liability, perpetual succession, then a transferability of shares, and last is calm and seal. Calm and seal. Now, one more feature will do. Okay, there are 3 features left. Next is company can own property in its own name. Okay, like, can I own property in my own name? Can you own property in your own name? Yes. Can company own property in its own name? Yes. Like, we are working for a company called as Veranda. Yes. So basically, who owns this setup? Veranda. Yes. Who owns this tube light? Veranda. Who owns that furniture? Veranda. Who owns this laptop? No, it is mine. Okay, not everything Veranda. Okay, the tab is of Veranda. So can company own property in its own name? Yes, obviously yes. Next, company can sue and be sued in its own name. Okay, like, can you sue me? Can you sue me? Yes. Can I sue you? Can you sue a company? Yes. Can company sue you? Yes. But when you sue a company, that suit will be against the company only, or the members and directors will also be involved in the suit? Answer, it is again against the company only, not against members and the directors. Like example, we studied CS Chaiwala Private Limited. So that debt, take of 98.5 lakh, it is our debt or company's debt? Company's debt. So creditors will sue the company, not us. Am I clear with this? And the last, this I love when I teach chartered accountant students. What does this say? Separation of ownership and management. Separation of what, beta? Ownership and management. Before I start with this, I'll check this, some messages are there. Okay, chalo. Now I want the answer. Okay, guys, in companies, especially in big companies, there is separation of ownership and management. Like, who is the owner of the company, beta? Who are the owners of company? If I ask you, who are the owners of company, what will be your answer? Answer, shareholders. You told. Don't use the word shareholders. Use the word members. In 15 minutes, 15-20 minutes, you'll understand why I'm telling this thing. Use the word members. And management is in the hands of whom? Board of directors. Yes. Okay. What is the answer coming? Shareholders. Okay. Management is in the hands of whom? BOD. BOD. Correct. So per se your answer is correct, guys. Board of directors. Per se is correct. Per se I am telling. But you know what? If your answer would be correct, exactly correct, if you are answering as per Companies Act 1956, not as per Companies Act 2013. Because, see, per se why it is correct, I will tell you. The reason is that, example, Not example. Example, I have 5 shares of Reliance. 1500 into 5, 7500. Example, there is a management meeting going on. Can I just kick the door and go inside? Hey, stop this meeting. The co-owner is standing here and you're doing a meeting without my consent. What nonsense is going on? So everyone will stand. Mukesh Ambani, Mukhya also. So he's my friend, so I can call him Mukhya. In the example, sorry Mukesh sir. Okay. Now, so Mukesh Ambani student will be like, sir, who are you? I'm like the co-owner of the company. How many shares you have? 5 shares. What will you do with me? Now, see what stupidity I am telling you. Just understand. You know what is the market capitalization of Reliance Industries? Market capitalization means very simple, number of shares multiplied by market price of 1 share. It is around 19 lakh crore. Out of 19 lakh crore, I am holding 7,500 shares. What will you do? I'll just say, like, sir, take this 10,000. Sir, turn, just kick me, get out. Yes or no? So management is not in my hand. Okay. So in big companies, management is like ownership is passive in nature only. So sir, who will own the management? Now you told board of directors, per se correct, but not exactly correct, because one committee, Harshendra committee, they asked one question to the drafting committees, the lawmakers here, that sir, when you say board of directors, it is not exactly correct. Just imagine what thought they had. Well, why? The reason they told, sir, in directors there are 2 types of directors: full-time director, part-time director. Full-time director we accept, 9 to 5 they are in the office, every day they come, they are employees of company and they are the backbone of the company, they are responsible for management, correct? But sir, there are part-time directors also who don't come every day in the company. They'll come only in the board meeting. Yearly 4 board meetings, minimum 4 board meetings are there. They'll just come there, give their expertise and go. So are they actually handling the management? No. So why are you telling board of director? Why are you involving them also for the people responsible for management? It is incorrect. So for the first time in the history of Companies Act, one word was devolved. And it is told that these people are responsible for management of company. These are the backbone of the company. Now, who are these people? Understand. Management will be in the hands of key managerial personnel. What we call beta? Key managerial personnel. Have you heard about KMP? Anytime. Like when you are doing articles, when you become CNR, you will continuously hear this word KMP. Very important piece. In bracket, I am telling KMP. So, sir, who are the KMP in the company? Which designations are KMPs in company? So, as per section 2 clause 51, KMPs are defined. Now, this is not the hierarchy I am writing. Randomly I am writing. Who all come under the KMP? First is CEO. Have you heard about CEO? Chief Executive Officer. Second is CFO, Chief Financial Officer. Then is whole-time director. I am writing in short form WTD, whole-time director. Then is managing director / manager. Have you heard about managing director? Yes. The next is company secretary. Company secretary, me. Company secretary. Okay. CEO, CFO, full-time director, managing director, company secretary. These so by default of law are the KMP. But apart from this, there is an amendment in this definition recently. What is told? Apart from this, if the board of directors think that somebody else should be made as a KMP, so they can add somebody else also as the KMP. But that person should be working only one level below the board of directors. Only one level. So I'll write it and explain you. Any other person appointed as KMP by board. board of directors, provided he is working how many levels beta? Okay, one level below the board of directors. So I'll explain you just what is this. See, I'll tell you the hierarchy of company. See, in the company at the top there is board of directors. In board of directors, WTD and MD by default are made as the key manager. Then below this are some people called as senior managerial personnel. Senior managerial personnel. Now who all come in senior managerial personnel? Understand. Okay. CEO, CFO. Some companies have CEO, Chief Operating Officers. CS is there. CMO, Chief Marketing Officer are there. Some companies have CTO, Chief Technical Officer. Some companies have CLO, Chief Legal Officer. All these chief, not chief, chief, or are senior managerial person. Okay. So out of this, see, whole time. Acha, below this example, there is operational head. Okay. Then there will be deputy operational head. Example. Okay. Now out of this beta, whole-time director, MD, CEO, CFO, CS by default beta are KMP. But if board of director want to make any of these people, okay, KMP, can they make it him the KMP? Answer is yes. But example, I am the deputy operational head. I am working here, Harsh. Can board of director make me the KMP? Answer is no. Why no? Because I am not working one level below. I am working beta 3 level below the board of directors. First level, second level, third level. So I should be working only one level below. Am I clear with this? Because that means, like example, the company has done some fraud and KMPs are liable. So what they'll do, they'll pass a resolution. They can make the peon of the company. You are the KMP now. Now he'll be like, I don't know anything. What is happening? Then the burden will be on him. So can they make him the KMP? Am I clear with this thing? So this is senior managerial personnel. So just imagine, beta, in case last year you are doing audit and at that time somebody else was KMP and this time they have added somebody else. So what will you check from them? Board resolution. And you'll see whether he is working one level below the board of directors. Do you understand? They might try to put liability on him. And a very lower level person, he doesn't know anything. So that is the reason. These are the frauds, probable frauds which can happen. Am I clear with this? Anyone has doubt? No? No one? Generally CA students have this doubt, right? You don't have any doubt. This doubt I answered in foundation. No. So people have this doubt, sir, why CA is not there but CS is there. Actually people don't have problem in CS being there. They have a problem CA is not there. So anyone has doubt here, same doubt here? I'll just clarify it. I'll tell you, see. Understand? Beta, these all these are this CEO, CFO, whole-time director, MD, manager, company secretary. These are all designations in a company. When they talk about company secretary, they don't talk about a person who has cleared his CS exams. They are talking about the company secretary of the company. All are designations. CS is a qualification as well as a designation. So if I become clear CS exam, okay, by default in any company, will I be the KMP? No, I have to take the position of company secretary of that company. Then only I will be the KMP. CA is a qualification, not a designation. Once you become CA and you are employed in a company, you might be the head of accounts, head of finance, director of finance, CFO. Once you become CFO, then beta you will become the KMP. Until that you will not. Like if you talk about Reliance, in Reliance also around 650 company secretaries are working today. 650 plus company, all are the KMPs of that company. No, only the company secretary of that company, her name is Savitri Parekh. She is the KMP. because she is the company secretary of the company, and that's the reason her package is in crores. Am I clear with this one? Understood properly? Okay, that is the point. Anyone has doubt in this? Online students? Sir, can the operational head be the member of KMP? No, because he is working 2 levels below the board. Only the senior managerial person, this chief word is there now. They will only become practically also. Am I clear? Understood? They are actually the person who are running the company. That is the reason. Okay. Now, so we have finished the features, or you can say the characteristics of a company. And in this, I hope you all learnt a lot of things. Now there are some other questions which I am asking. Just tell me true or false. Okay. A person holding entire share capital of company can be a nominee under insurance of stocks. Stocks means goods, guys. Goods. True or false? Come on. True or false? False. Okay. False. 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 True. False. 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 Okay, good. Answer is false. You know why? Now, people who didn't understand the questions, no problem. Starting with there will be a problem to understand the questions and crack it down. No issues. With habit, will practice, will develop this. See, what does it mean? A person holding entire share capital of company can be a nominee under insurance. Like, do you remember? I told you the example, I have 1 crore rupees. I have put in the company. After I put that 1 crore rupees in the company, that 1 crore rupees is of whom, beta? Me or the company? Companies. Out of that 1 crore, they purchase some goods. So who's the owner of the goods? Me or the company? Company. Right? Now, when insurance is taken of that goods, okay, who should be the nominee? The owner of the goods. He should get the money. Who's the owner? Me or the company? Company. So what I have written, a person holding entire share capital. I hold the entire share capital of company. Can I be the nominee under insurance? It is the company which should be the nominee. Am I clear? In foundation, we had a case law. Take a Mercura versus Northern Assurance Company Limited. Okay, that is the reason foundation people might answer. Okay. Answer this. These are basic questions, just for knowledge, will not come in exam. Can a company be a citizen of India? Is a company, or can a company be citizen of India? Yes or no? Yes or no? Answer is no, because citizenship is given only to natural person. Company is an artificial person. So answer is no. Acha, you have done tax, so obviously easily you can answer this one. Can a company be a resident of India? Can a company be resident of India? Yes or no? Answer is yes. Company can be resident of India. Resident means for individuals. If you have stayed in the preceding year for how many days? 182 days or more. Then this year you will be resident of India. Same, if the company's registered office is in India, it is a resident of India. Am I clear? Everyone up till now? Acha, one doubt I have. You didn't have this doubt, na? I have this doubt. I'll ask. See, everywhere I wrote here CEO, CFO, whole-time director, MD/manager, company secretary. I could have written MD then manager, na? Why did I write MD/manager? Managing director/manager. Why did I write like this? Not almost the same. They are defined separately, but it's a rule that boss in a company you can either appoint managing director or manager. You cannot appoint both. Now, if you see the definition, this is just for your knowledge. You'll get in all this in your finals. Managing director means a person who has substantial powers of management of company given by either articles of association or by members or by board or as per the contract with the company. 4 sources, and only he can exercise that powers, nobody else. Manager means a person who also has substantial powers of company but given by board of directors only, and only he can exercise the power, no other director. The MD manager more or less same, and that's the reason you cannot appoint both. Just imagine some auditor is there, he doesn't know this rule, like 5 minutes before you also did not know, and company has appointed a managing director, manager both, and they are giving them 10 crore rupees ka remuneration. Isn't it a fraud of 10 crore easily? Without knowing companies that, can you do audit properly? Impossible. That is the reason I say for being an auditor you should be brilliant in companies that. Okay, understood everyone? Online students? Yes? Good answers, online students. Very good, very good. Great, great. You online students, you know now how to raise hand. So next time I will take as a vote, like if I ask true or false, how many people say true? Raise your hand. So you should raise your hand. Okay. Then how many people say false? Like that. Great. Good. Now, so we have done this features as well as what is a company and all. Now one small topic is there, and then introduction of company is finished. The basic things will be finished, and that concept is lifting of corporate wheel. Lifting of corporate wheel. Now what is this concept? And I'll give you a practical example. Practical example of that. Lifting of corporate wheel. Sir, what do you mean by wheel? What is wheel? Online students, what is wheel? Tell me. What is wheel? Correct. Wheel means curtain, or in Hindi we say parda. Of limit, I'll explain. Okay, don't worry. See, so wheel means curtain, or in Hindi say parda. Lifting the corporate wheel, lifting the parda. There is a song for this. In Hindi it is a song. Okay, the song is like पर्दे में रहने दो, पर्दा ना उठाओ, पर्दा जो उठ गया तो फिर. Then lifting of corporate wheel will happen. Many people have this song in their mind. When I say lifting the wheel, lifting the parda uthana, like I don't understand why they have this song. Choli ke piche kya hai? Many people get this song. I don't understand what is the connection of choli ke piche kya and parda uthana. Okay, but it's fine, no problem. So what is this lifting of corporate wheel? See, I am writing here company, and here I am writing person forming and managing the company, basically promoters, directors, the company. Tell me, these two people are same or different? Tell me. Different, obviously, na? They are different. So which concept makes them, these people, different? Companies Act. So it is assumed that Companies Act has put a wheel in between, and because of this wheel they are different. Am I clear? Sir, this is the wheel. I have made a designer wheel. Okay. Sir, if we, because of this wheel, beta, they are different. But if we lift the wheel, then they will be same or different. Then they will be treated as same. If we lift the wheel. Am I clear? So, sir, when is the wheel lifted? See, I'll tell you, there have been many cases. There is no section as such which tells that wheel should be lifted. But there have been many judicial cases where people started doing fraud in the name of company. Let's say, I'm a company secretary. I know Companies Act to some extent. What I did now, I did some fraud. I formed some company and I started taking loan in the name of company. And I started spending that money. At the time of repayment, what I told investors, sorry creditors, the company is into losses, we can't pay the money. At the most, but I know, okay, it is my debt or company's debt. Company's debt. Can they sue me? What I know, at the most, they'll wind up the company. And they will wind up the company. I'll form a new company, again take loan. Isn't it a fraud or not? So people actually started misusing the corporate personality concept. And people started doing fraud in the name of company. But the judges sitting there, they don't sit there because their wives don't allow them to sit at home. They are the best brains of the country. So whenever they find that cause a company is found for doing fraud, for dishonest activity, they know company doesn't have a brain to do fraud on its own. And there are some people who are sitting behind in the name of company and doing that fraud. And in order to punish them, in order to demas them, the wheel is lifted, treating that company and the person doing that fraud, same person in the eyes of law. And thereby they will be punished. Am I clear with this? Understood? This is the major purpose of lifting of corporate will, to punish that person who is doing fraud. So for this, there is one actual case. Shrishant, fast bowler. India's first World Cup, T20 World Cup. If you see, India won the first T20 World Cup. Misbah-ul-Haq, he lifted the bat, and their short fine leg. This guy was standing, Shrishant, he took the catch. So Shrishant is now banned from playing for India and for his states. He has entered in movies, politics and all. Why? Because now he was caught in terms of betting and gambling in IPL matches. And when he was caught in the news, it was shown. What he told, everything is done in the name of my company. He was not doing. So in the news itself, it was shown, in the MOA, Memorandum of Association, it was written, the main objects of the company is to carry on the business of imparting training in the field of sports, and to buy and sell sports equipments, and to further involve in betting and gambling of sports events. It was literally written in the news, it was shown. But can company do betting and gambling on its own? No. So basically that point was removed from MOA and the wheel was lifted, treating Shrishant and his company same person in the eyes of law, and thereby he was punished. Am I clear with this? Understood? Okay. Vijay Mallya also same case, because he was also involved in. Now he's coming and telling the same thing. I was just a guarantor. Yes, I have video of this also. Just a guarantor, but he was also involved. If you'd have time, we'll discuss that case also. Don't worry. Okay, understood everyone? Clear? Yes. And there is a funny thing how he was caught, Shrishant. Actually, the commissioner and the police department got a news that some you can say terrorist activity is going to happen, and there is a call going to happen on that. And they tapped the call and they understood this betting and gambling is happening and Shrishant is involved. Just imagine they are trying for something else and he was caught. This is called as bad luck. Happens, no problem. I'll explain. Okay, lifting of corporate will. Yes, see, understand. See, whenever a company is formed for illegal purpose, for doing fraud or dishonest activity, okay, so can a company do fraud on its own? Obviously not. There are some people who form the company and do fraud in the name of company. So I told you I'll form a company, take loans in the name of company, and ultimately I'll not repay it because I'll spend on my personal evil purposes. And at the time of making the payment, at that time I'll tell the creditors, oh sorry, company is into losses, we can't pay the money. So basically this is a fraud. Ultimately, I know that they will sue the company. Me and company are not same person, and I'll vanish out. So for illegal purpose or for purposes, people started forming company. And should the company be punished or I should be punished in this case? I should be punished. And therefore the wheel between me and the company will be lifted, treating me and the company same person. I took the loan, I did not repay the loan, and I'll be punished for that. Did you understand? Understood, Muskan? Clear now? Yes? Okay. So here we finish our introduction part. See, coming back here, I told the preliminary part first will be introduction to company. In that, did we cover definition? Yes. Did we cover the features? Yes. Did we cover lifting of corporate will? Yes. I will just read from JKSC book what we have covered. Take a 2 minutes reading will do. Then we'll go to the actual part. Okay, let's start. Online students, you have the books, physical books. Not there, na? But which book they have got? I have to see. You have the physical book. In that lesson 1 is there, preliminary is there. Is preliminary there? Oh no, okay, no problem. I'll show it. I'll share it with you. No problem. Yes, everyone can see properly. Yes. Let's zoom more. Now. It's blur. Let me check. Is it blur? Is it clear or it's blur? Online students. Yes. Yes, Aman. Wherever it is found that company is found for dishonest purposes, the wheel will be lifted. Now it's fine, no problem. Okay. See, let's start. Definition of company. The term company has been defined in section 2 clause 20 as per this company means a company incorporated under Companies Act 2013 or under any of the previous law relating to companies. We have done this thing. Formation of company. A company may be formed for any lawful purpose. But a may here has to be treated as shall. Company shall be formed. Then sir, why they have not written shall? They are telling beta a company may be formed for lawful purpose. That means is it mandatory to form a company? No, you can form a sole proprietorship. You can form a partnership. You can form a LLP. You can form a company also. The company may be formed. But if you are forming a company, can you do it for unlawful purpose? Khatri Supari and Associates Limited. Main business extortion, murder, kidnapping. No, not for that. Okay. So company may be formed for any lawful purpose if you are forming a public company. What is the minimum number of members to form a public company? 7. If it is a private company, if you are forming a normal private company, minimum members 2. But there is a concept of one person company now introduced. We'll talk about that properly. One person company. Then beta minimum number of member 1. One person company itself, the name tells one person, a company with only one person as member. Am I clear with this thing? Okay. That is to say, a private company, one person company is a type of private company. By subscribing their names or his name to memorandum and complying with the requirements of this act, that means by signing the MOA. When you sign the MOA, you become the first member. So in a public company, how many people should sign? 7. Private company, 2, and one person company, 1. Now, the Companies Act is applicable to which all entities? Companies. Normal companies, yes. Insurance company, banking companies, electricity companies, or any other company formed under Companies Act but regulated different act. To them also it is applicable, but it is provided it is not going against their respective acts. Yes or no? The provision of this act shall apply to companies incorporated under this act or under any previous company law. Insurance companies, except in so far as the said provisions are inconsistent with the provisions of Insurance Act or IRDA 1999, then that act will be applicable. Banking companies, except in so far as the said provisions are inconsistent with the provisions of Banking Regulation Act. Companies engaged in the generation of supply of electricity, except in so far as the said provisions are inconsistent with the provisions of Electricity Supply Act. Until it doesn't collide, Companies Act will be applicable. If it collides, then that respective act will be applicable. Any other company like NBFCs, I told, governed by any special act for the time being in force, except in so far as the said provisions are inconsistent with the provisions of such special act. But I told you for other body corporates also Companies Act can be applicable, but only as per central government notification. Such body corporate, see, all other artificial person. Did you understand why I focused on those words properly? Incorporated by any act for the time being in force, as the central government may by notification specify. Example, FCI, Food Corporation of India, formed under FCI Act. NHI, National Highway Authority of India, formed under NHI Act. For them also Companies Act will be applicable, but as per central government notification. Okay. Now, characteristics. We'll just see the head points, huh? Okay, because it is not in the exam. Have we covered? Separate legal entity? Yes. Limited liability, have you covered? Yes. Perpetual succession? Yes. Separate property, company can own property in its own name. Transferability of share, guys, in which company shares can be transferred? Public or private or both? Both. Very good. Then beta, common seal. Yes, we have done that. Then capacity to sue and be sued. Then separate management, beta, ownership, separation of ownership and mercy. KMP and all, it is only managerial person, but they have not explained everything. We have properly written in notes. And voluntary association for profit. Obviously, will you form a company forcefully or voluntarily? Voluntarily. Simple. Am I clear with this thing? So company is a voluntary association for earning profit. What is the meaning of company? You know, COMNPANY, come and punny. Come means coming together, funny means for earning bread. That is the meaning of company in Latin. Am I clear with this thing? For profits, it is formed for the accomplishment of some public goals, and whatsoever profit is gained is divided amongst its shareholders, like dividend. Am I clear with this? Okay. Just tell me, but is company a citizen or not? No, obviously, company cannot be citizen. Does a company have, is a company better residence? Can a company be resident of India? Answer is yes. Am I clear with this thing? Okay, so it cannot be citizen, but yes, it can have residence. And does it have nationality? Yes. If it is formed in India, it is an Indian company. Simple. Better then lifting or piercing of corporate will. See, what is this? Lifting of piercing of corporate will. Corporate will, it refers to a separate legal existence enjoyed by the company, which is distinct from the people who own and manage it. It is an artificial curtain created by law which separates company from the people who own and management. We also made a curtain. Effect of corporate will, they will be treated as same or different? Different. Only company is liable for the acts or defaults done in the name of company, even though the directors, employees acted on behalf of company. Company is liable, like we said, 98.5 lakh. Will we be liable? But lifting of corporate will, once it happens, it means looking behind the company as a legal person, that is disregarding the corporate entity and paying regard instead to the realities behind the legal facet. You actually see the realities. Who's actually running the company? Can you make him punishable? Where the courts ignore the company and the concern themselves directly with the members or managers. They treat company and the members and managers are same. The corporate will may be said to have been lifted. Only in appropriate circumstances, courts shall lift the corporate will. Like whenever fraud is done, tax evasion is done, okay, alien enemy character, foundation we had this case laws in, okay, Shrishan, okay, for doing betting and gambling, okay, for illegal purpose if you do form company, the company's corporate personality will be disregarded and the person who's doing that wrong thing will be punished. Am I clear with this? Yes. Coming back, okay, to this point, one question I have to add, you would answer this. Sixth question, sixth one. The concept of corporate personality, the concept of corporate personality of company is absolute in nature, is absolute in nature, true or false? True or false? Tell me. Okay, good. True or false? True. Some people say true, some people say false. False. Okay. Answer is better false. Now, people who didn't understand the question, I'll explain the question. See, the concept of corporate personality. What do you mean by corporate personality? Separate legal entity. The company and the person forming the company are same person or different? Different. This concept is absolute. Absolute means whatever happens in this world, these two people will be different. They will never be treated as same. Can they be treated as same? Answer is yes. Okay, what is that concept? Lifting of corporate will. Just we decide. So answer is the concept absolute or it has exceptions? It has exception. It is not absolute. Now same question in simple format if I ask now, what will be the question? Explain corporate personality of company and also state whether it has any exception. So everyone will write. But the same question if it is given in this format, many people get confused. Okay, so answer is false. I hope I'm clear with this point. Yes. Okay. So we'll start with now classification of company. Okay, but I'll take 5 minutes break, and I think you also need a 5 minutes break. So we'll take 5 minutes break and then we will start continuing. I hope I'm clear with this online student. Yes. Okay, great. 5 minutes break will take. Okay. So now we are starting with a new concept that is called as classification of company. What is that called? Classification of company. And it is very important for you. Classification of company. Now understand, we should first, before we go for classification of company, we should understand what is the meaning of classification. We are not studying types of companies. Types are only two, public and private. Classification means classification is done under certain basis. A classification basically means there is one thing, we can classify that thing under different heads. Like if I say one name, what's the name? Yash. Yash. This is a person. I'm not teaching you types of Yash. I'm teaching you classification of Yash under certain basis. Like, can we classify Yash on the basis of gender? Male, female? Yes. Can we classify him on the basis of age? Major, minor? Can I classify him on the basis of marital status? Yes or no? That married, unmarried, committed, wherever. Then can we classify Yash on the basis of nationality, Indian, non-Indian? Can we classify him on the basis of religion, Hindu, Muslim, Catholic, Sikh, Jain, others? Yes. So basically it is one person, but we can classify him under certain heads. So he'll fall under certain brackets. Same if it is a Yash Limited company. So we will be classifying one company under different heads. Did you understand? Now why this classification is important for us to study? This is very important for CA Inter also and for being a chartered accountant also. Why, sir? I'll tell you in some time. Not in some time, now itself I'll tell you. See, guys, if I ask online people, please answer me. What is the starting package you are expecting as a chartered accountant? Starting package you are expecting as a chartered accountant. You answer. Starting package, how much you are expecting? $14 lakhs, okay. 7 lakhs, okay. More than 10 lakhs, good, good. 8 to 10 lakhs, yes. Average everyone is between 8 to 15 lakhs, correct? So now I have, sir, what is written? 11M or 1 essay, what you have written? I didn't understand. Okay, so everyone is between 15 lakh and all. Now my question is, why should I pay you 15 lakhs? Can you answer to that? Why should I pay you 15 lakhs or 10 lakhs, 11 lakhs? It's a big amount, right? Why should I pay you? Or why would I pay you? Okay. As a CA, why would I pay you? Why should I pay you? This question would be asked to you. Or I can sign in a company's audit report. No, if you are working in a company, external auditors will come and audit. You will not be auditing. I am asking you, if you are working in a company, why should we pay you? Okay, knowledge. That knowledge would to repay our investment in study center. Okay, okay. That you did for me or for yourself studies? Why should I pay you? For having good accounting knowledge which help them to pay less taxes. Okay, you reduce taxes. Okay, so good. Some basic knowledge. Okay, I'll tell you the reason. See, why I asked you this question now? To understand whether you know what you will be doing as a chartered accountant. So see, understand. Our role, majorly our role is advisory. Like when you are working in a company, Companies Act will be applicable. From foreign, if money is coming, Foreign Exchange Management Act, RBI Act is applicable. If it is a listed company, SEBI Act will be applicable. Then you have to deal with accounting standard. It is also a law. Income tax, it is also a law. Income Tax Act 1961, GST. So basically our work is advising the board of directors how to run the company so that as per the acts, as per the law, so that they don't incur penalties. And our major role comes into picture now when I'll tell you. See, every act has an authority. Like under Companies Act, one of the authorities is ROC. Under Income Tax Act, it is CBDT. Under RBI Act, obviously Governor General of RBI Governor. So these authorities issue notifications. We have to read the notification and tell the board of director whether that notification is applicable to our company, and if yes, then how should we change the working of our company, because you may have to adopt new people, take upon new people, adopt new softwares and all. So before advising the board of director, first we should know whether this notification is applicable to our company. And this notifications comes in two ways. One notification is general, applicable to all companies, but one set of notification are applicable only to certain classified companies. So before we know whether we come to know whether the notification is applicable to us and advise board of director, we should know under which classification our company falls. And that is the bloody reason classification of company is hell not important for us professionals. If we don't know whether under which classification our company falls, what will we advise the board of directors? Am I clear? That is the reason we are studying classification of companies. Okay, clear? So see, sir, You told classification is always under certain basis. What are the different bases of classification here? See, companies can be classified as, I'm writing, on the basis of, on the basis of. First, on the basis of liability of members. Sir, how is the liability of members? On that basis we can classify. Second, on the basis of members. Sir, who are the members? How many members there can be? On that basis. Next, on the basis of control. Sir, one company controlling another company. On that basis. Next, on the basis of capital. Listed companies, unlisted companies. And then comes the last, other companies. Now what people think, na, other companies, it is miscellaneous, others. No, it is from here only questions are asked nowadays. So don't take it as miscellaneous. Okay. So these are the bases. So now first properly understand, there are certain myths which you people have in your mind now. I'm going to remove your myths, all these myths from here. So first basis, let's start with the first basis. First is very good, Aman, very good. Okay. Now first is on the basis, pay proper attention in classification, because if you don't pay proper attention, I know when I'll teach you the big technical topics, at that time you'll be like, sir, but if it is a government company you told, then why are you telling if it is a private company? How can a government company be private company? All these questions you'll have. Okay, so pay proper attention so that in the bigger lessons you don't get any kind of confusion. And once all these basics are clear, reading the question paper becomes very easy for us. We exactly understand what he is trying to ask. First, on the basis of liability of members. Sir, how is the liability of members? On that basis, we are classifying companies into two parts. First is limited liability company. What we call beta? Limited liability company. And second is unlimited liability company. Unlimited liability company. Sir, limited liability company means what? Very simple. Here the liability of member is limited. But sir, limited liability company. Sir, then what is unlimited liability company? Here the liability of member is unlimited. There is no limit on the liability of member. But sir, you told liability of member is limited as per the second point. I told, but obviously there in law there are exceptions. I'll tell you about that also. Don't worry. Now limited liability company. In limited liability companies also are divided into two parts. Sir, how is the liability limited? These are the two parts. First company is company limited by shares. Limited by shares. Limited by shares. And second is company limited by guarantee. Here I'll tell you why did I tell you separation of ownership and management. Don't use the word shareholders. Limited by guarantee. Okay. Now company limited by shares. It's very simple. Section 2 clause 22. Sir, company limited by share, I mean these are the companies which have issued shares. And how to become members in this company? By buying shares. And if you have purchased shares, my liability, if I have purchased share, my liability will be limited up to what, beta? Unpaid face value of shares held by me. Simple. In fact, all the companies which you people know are all company limited by shares. If I tell you to take name of some companies, will be like Tata, Reliance, and yes, these are groups. But in that also many companies are there. But the companies which you people know are company limited by shares only. Am I clear? because you know only listed companies listed on the stock exchange. All are company limited by shares. Okay. Now, you know how many companies are registered in India till date? Around 28 lakh companies are registered in India. Out of that 28 lakhs, only 5 to 7,000 companies, not 5, 6 to 7,000 companies are listed, if I am not wrong. And out of that 6-7,000 listed companies, we know the name of 5-6 companies. That is our knowledge as to company. Okay, but yes, it will grow. Now, company limited by share. Here, the liability of member is limited. Sir, limited up to unpaid face value of shares. Example, here I am writing A for some reason. Example of this company is Reliance Industries Limited, then beta Tata Industries Limited, okay, Tata Consultancy, yes, Consultancy Services Limited, okay, in short TCS. All these are okay, company limited by shares. Hindalco, okay, HCL, all these are. Now, what is company limited by guarantee? Section 2 clause 21. Now, what is this? What are these companies? See, these companies, now understand properly, these companies generally don't issue shares. I'm using the word generally. That means exceptions are there. These companies generally don't issue shares. So, sir, if these companies generally don't issue shares, so how to become members in this company? We can become member by giving a guarantee of a particular amount. And that guaranteed amount is written in the memorandum of association. Like example, 1 lakh. So when I become the member of the company, at that time, beta, I don't pay anything. I have to give a guarantee of 1 lakh. So I am promising that when the company will go into winding up, at that time, my liability, irrespective of the loss of the company, 10,000 crore, my liability will be limited up to how much? 1 lakh towards the company. Am I clear with this? Understood properly? And this money can be called only during winding up, not before that. So here, liability of members is limited up to the guarantee given to contribute towards the assets of company during winding up only. Winding up only. I am writing here B. Okay, did you understand? I'll ask you one interesting question which was asked to me in interview. I went to the interview for the job and he asked me, what is the use of for member if they give guarantee to come? I'll come to that, don't worry. See, what is use for member? Like why will the member give guarantee? Okay, I'll come to that. See. Understand? I'll now only tell you, like if it is a profit making company, you will get dividend on the basis of guarantee you have given. Like if it is written, like any person who has given guarantee of 100 rupees will get 1 rupee dividend. Dividend is distribution of profit. So on the basis of your guarantee, you will get the dividend. Okay, like that. Now understand. I went to the interview and he asked me one question, ki Harsh, what is company limited by guarantee? I told this. He gave me the BAR Act. And read. I read it. So he told me, Harsh, I understood. You know what is company limited by guarantee. Can you explain me? Because what was his understanding, he told. You see, the liability of member is limited up to the guarantee, which one will called only during winding up. So he told they could have directly written, na? Liability of member is limited up to guarantee given, okay, to be paid during winding up. He asked me, what is the meaning of this line? To contribute towards the assets of company. What is the meaning of this line? This is how they check. If you go to big fours and all and big firms, they'll ask you, they know you have read and come, but did you actually understand the prospects of that? That is what they'll check. Come on, can anybody tell me? Here, you also can tell. Okay, good try. And others online? 10 people. This is how the interviews will be taken in big firms, like big four and all. The last round questions and all. Asset used to pay liability like money. I'll tell you. I'll ask you one question. Tell me, share capital comes on the liability side of company or asset side of company? It is a liability or asset for the company? Liability, yes. Why it is a liability? Why it is a liability? Because during winding up, okay, you have to pay back that amount. Share capital amount you have to pay back to the members. So during winding up, it is payable for the company or receivable for the company? Payable. Payable is a liability or asset? Liability. But this amount, guarantee amount, during winding up for the company, it is payable or receivable? And receivable is a asset or liability? Asset. So during winding up, the liquidator will treat this amount as an asset. Am I clear with this? This is the meaning of that line. So this is how they will take your interviews and all. Okay, they know you have read and come, but they are there to reject people. So only the person will answer everything properly will be selected. Understood everyone? Online students? Clear? Okay. Now here I wrote A and B for a reason. Okay. Now understood. See, guarantee companies are also classified into two parts, divided into two parts. One, guarantee companies not having share capital, and guarantee companies having share capital. You remember I told you generally these companies don't issue shares. Yes? So sir, there are two types of guarantee companies. One which issues shares and which doesn't issue share. Generally you will find guarantee companies not issuing shares because which I have seen, guarantee companies are there, they are in the form of non-profit companies. Have you heard about Section 8 company? Companies formed not for profit, NPO, and they are formed in that way. So these companies don't issue shares, they just take guarantee from the members. But sir, if these companies don't issue shares, so how does the company run? So initial funds are given in the form of grants and loans by the promoter and all, and that is how the company starts working. And later on, when the company starts earning money, okay, that amount given as loan and all is repaid back to the promoter. Am I clear? The entire money is given by the promoter itself at the starting stage itself in the form of loans, debts. Okay. So basically, not having share capital here, so the company doesn't issue any shares. So how to become members, beta? Just by giving guarantee. So here liability of member is limited up to what, beta? The guarantee given to contribute towards the asset during winding up. The liability of member is limited up to B. It means this. But example, I'll give you example of this company. Indian Cricket Association. BCCI has formed a company under it, a Section 8 company, non-profit company, which is a company limited by guarantee, not having share capital. Okay. These words please remember in the technical lessons, it is very useful. And guarantee company having share capital. These are generally profit based. One company I know, okay, the name of the company, example, I'll write it here, example, the name of the company is Bhupa Life Insurance Company Limited. Have you heard this name? Like Max Life Insurance, you know, Bhupa Life Insurance has been merged into Max Life now. It is Max Bhupa Life Insurance Company now. Am I clear? So Bhopal Life Insurance Company, I still remember when the company in the newspaper they were raising money. So what they gave an ad that if you want to become a member in the company, you have to buy shares of 20,000 rupees. Yes, you have to buy shares of 20,000 and you have to give guarantee of 5 lakhs. So this company will issue shares also, but very less amount. Okay, but guarantee amount will be big. So if you want to become a member, you have to subscribe to both the shares also and you have to give guarantee also. So here beta, the initial funding 80% of that promoter will give by issuing by loan and all, but the rest 20% will be raised by the company by issuing shares. I mean, so if you want to become a member, you have to buy the shares also and give guarantee. So here liability of a member will be one side or two side, twofold. That's for the share amount is liability will be limited up to the unpaid face value of share, which will be called only during winding up or anytime. But the guarantee amount will be called only during winding up. Am I clear with this? So here liability of member is limited up to, I am writing A plus B. Did you understand? For the share amount, A limited up to the unpaid face value of share, and for guaranteed amount up to B. Guaranteed. Clear? I'll tell you. Wait. What if the person is unable to pay the guaranteed amount? But he is personally liable for that. When MOU is signed between the company and the member, that boss, if you don't pay the money, okay, your assets will be liable for that guaranteed amount. Okay. For internal audit. Sir, could you explain again? Contribute towards assets. Yes, I'll explain. See, contribute towards asset means, see, share capital is a liability for the company. Why? Because at the time of winding up, you have to pay it back. Correct? That share amount, which example, I am the member of Reliance. When Reliance goes into winding up, they'll sell the asset, pay the debts, and my share amount, what I have paid, they'll give it back to me, my capital. It is payable for them during winding up. But this amount, okay, the guarantee amount, during winding up for the company it is receivable, because as a member I am going to pay it. So for me it is payable, but for the company it is receivable, and receivable is a asset. So they are telling better during winding up, liquidator will treat this money as a asset. Before winding up, it will be shown in the notes to account. Okay, this is the contingent asset. After once winding up starts, it will come in the balance sheet. Am I clear with this? Understood? Clear? Now, so this is company limited by guarantee and company limited by shares. Okay, now why did I tell you better don't write shareholders as owner? Because better company limited by guarantee not having share capital, they don't issue shares, so there is no shareholder. But are all the people who have given guarantee members? Yes, that's the reason use the word members. Clear? Okay. Now unlimited company. Section 2 clause 92. Now what is this? Let's see. Unlimited company is very simple. Here there is a company with no limit on the liability of members. No limit on the liability of members. And I'll tell you, nowadays you will not find that many unlimited companies, but there are. I'll give you examples also. Now these companies were formed in the era of 1970 to 1980, in between that, where see the company's concept, forming company concept, why company concept started, or why government started? For economic development, because people were scared to start with business because of unlimited liability. If they start with sole proprietorship, they are personally liable. Now governments wanted people to enter into businesses, do business, because when the business grows, the country grows. And then company concept started. But what happened? People started forming companies, but the creditors were scared now, because they knew that there is limited liability, like 98.5 lakh loss. Our case, it is of the bad debts for the creditors. So creditors stop giving credit to companies, and the whole concept of forming company beta backfired to many nations, including India. At that time beta unlimited company concept started. So promoters started forming unlimited liability company to tell the creditors that you wanted a big organization to give credit. We are company, we are big organization. Second, you were scared that your money will be doomed out because of limited liability. Don't worry, it will not be doomed out. Okay, we are taking unlimited liability. And then beta, okay, creditors again started giving credit. So that was the purpose, because people were very skeptical at that time, very orthodox. So at that time, ticket to boost confidence, to show confidence for these creditors, unlimited companies concept started. Am I clear with this? But now there are very less. Okay, because now people are more matured. Okay, now the partnership also has become limited liability. But there are unlimited liability companies. I'll give you examples also. Like first example is have you heard about this company? Discovery Channel. What is the name of the company? You know, actual name, Discovery Communications Private Company with unlimited liability. So Discovery Channel is an unlimited liability company. Did you understand? One more. Reebok. Have you heard about Reebok? Reebok India is also an unlimited company. Reebok India private company with unlimited liability. There are many US based companies also which are unlimited liability companies. There are, in fact, you know, in Surat, the place in Gujarat, very famous for diamond polishing. So almost all companies were unlimited liability company, because while polishing something goes wrong, the diamond loses its value. So people started forming unlimited companies, diamond polishing companies, or well unlimited. You will get a list of that. But now after 2000, 2005, all have been converted into limited liability companies. But initially all were unlimited. Am I clear with this? Okay. Now, sir, but one line is there, important line in unlimited liability company. What is that line? See. However, members of such company are not directly liable to creditors as are partners of a partnership firm. This question has come in CMA Inter recently. Now what is this line? Let's understand. See, what students ask me question is, sir, that if I am a partner of a partnership firm, tell me better, partnership firm and the partners are same person or different person? They are same person in the eyes of law. Firm doesn't have separate legal identity. So if I start a partnership firm and partner, the firm's debt is my debt. And if I don't pay the firm's debt, okay, sorry, if the firm doesn't pay the creditor's debt, can the creditors directly sue me or not? Yes, I am directly liable to them, because firm's debt is my debt. But if I am a member of an unlimited liability company, me and the company are same person or different person? Different person in the eyes of law. So any debt taken by the company is my debt or company's debt? Company's debt. Yes, I accept I have unlimited liability, but that debt is not my debt. So creditors will sue whom beta? The company. The company will issue a notice to me through liquidators that, boss, you have unlimited liability, you have to pay this much. Am I clear with this? I'm not directly liable to the creditors. And in that also, no, there is a bifurcation, just I'm telling you. Like example, there are four partners, four members in unlimited liability. I take 25% profit, B takes 25%, C takes 25%, D takes 25%. So when the liability comes, that also will be divided in that proportion only. I will not be paying more than the 25% of the liability. Am I clear with this? Just for your knowledge and understanding. Am I clear with this? Understood everyone? Clear? Classification of company on the basis of liability of members. Okay. Example I'll just write for you guys. Okay. If anybody asks, example. Okay. Discovery Communications. Next one more is Reebok India. Am I clear? Sure. Now, so this part is done. Online students, any doubt? I hope I'm clear with this. Yes? Okay. Sure. Good. Now the second basis of classification, that is classification. I have written it earlier. I'll just write on the basis of members. Classifying company on the basis of members. In fact, I'll tell you now, this is types of company only and the most important basis. Most important basis. Okay, yes. What is this beta? Public company and private company. Now many people have this confusion. What is public company? What is private company? Public means government companies. I'll clarify all the doubts. See. Private company and public company. Okay. See. Sir, first we'll understand what is public company. Any doubts? Unlimited liability, last point. Yes, see, in case I am a partner of a partnership firm, me and the partnership firm are same person in the eyes of law. So any debt taken by the firm is my debt. So in case the firm doesn't pay the creditors, it is as good as I have not paid. So I am directly liable to creditors. But in case I am a member of an unlimited liability company, then me and the company are different person in the eyes of law. So any debt taken by the company is not my debt. This company's debt. So will I be directly liable to the creditors? Can the creditor directly come and hold my collar, pay my money? No. Obviously not. Yes or no? So basically they will give notice to a company. Company, you have to pay this much. Company will issue notice to me that boss, you have to pay this much amount. You have unlimited liability. So I have unlimited liability, but towards whom? Towards the company, not to the creditors. Am I clear? Understood? SA. Can you just write your name? SA South Africa feeling I am getting. Okay. Now, so what does this say? SA Akshata. Okay. Now, I'll call you Akshata. Okay. Now, better, what is public company and private company? Very important. Like if you are a chartered accountant and anybody tells you, hey, what is public company and private company? We're like, I don't know. It will be like a doctor doesn't know what is a stethoscope. Am I clear with this thing? So it's very important. So what is public company? Section 2, clause 71. Anyone knows what is public company? Which is listed? Okay. It's not private. You saw in the book and telling. Okay, you are telling again features. See, this is the mistake what you do while writing answers. You write explanation features. They want law, that's it. So answer beta, what is public company? You know what is public company? Public company means a company which is not a private company. Simple, very simple. Public company means a company which is not a private company. So simple, na? But I'll tell you in law, anything which is very simple na, is actually very intrinsic. Because so many things are included in that they cannot write it down. And that's the reason better they make it in a very simple way. They write it in a very simple way. So see, public company means a company which is, or I'll say other than, company other than private company. You might have heard na, like, see, they are silent on many things. Simple definition and silent on anything. You might have heard na, like couples, lovers, they say, I will find anyone who can understand my words, but I want someone to understand my silence. So basically these definitions are like that. I want a CA who can understand my silence. Okay, so we'll understand, don't we? We'll be lovers because CA is our love marriage, not arranged marriage. Yes or no? Is it anyone's arranged marriage? No, it is our love marriage. So we'll understand our lover properly. So public company means a company which is not a private company. Okay. Now, what is private company? Section 2, clause 68. Very important definition. Very important. See, what is private company? Understand. Private company means a company which has 3 restrictions in the articles of association, in the 3 restrictions. If all the 3 restrictions are there, it is a private company. Any one restriction is missing, it is which company beta? Public company. So public company means a company which is not a private company, means actually a company which doesn't have all the 3 restrictions in the articles of association. Am I clear with this? Understood? Okay, so for which are the 3 restrictions? Okay, which is the heart of demarcation of private company and public company, on the basis of which the whole Companies Act is made. Okay, if this heart is not there, beta, the whole Companies Act will be ruined. So which are the 3 restrictions? See, private company means a company which by its articles of association, okay, restricts, I'll not write here, I'll write here, which by its first A point restricts, this one to we have already done, restricts transfer of shares. What is the first one? Restricts transfer of shares. Have you done this or not, beta? Public company shares freely transferable, private company transferable but subject to restrictions in the B. Except OPC. Forget about this for the time being. OPC means what, beta? 1%. Restricts number of members. To how much? Perfect. 200. So what is the maximum number of members in a private company? 200. Please remember this thing. Lot of confusion happens in the technical topics. In fact, after being a CS also, I was having many doubts in this 200. Okay, I'll ask those questions also to you in the further lesson. But beta, when we count 200, and when you count 200, certain adjustments you have to do. What is the adjustment? Adjustment number 1. I'll change the ink. Adjustment number 1. First, joint shareholders are counted. How much, beta? Counted as single. Counted 1. Am I clear with this thing? So joint shareholders, people who have jointly purchased shares. Hey sir, why will anyone buy one share jointly? Array, do you remember Tata Sons Private Limited? One share 1 crore ka hai. Anyone has? No, na. So we'll buy it jointly. In fact, beta, even your 1 year or 5 years package also may not be adequate to buy that share. Okay, so we'll buy jointly. Don't worry. Second, everyone will buy it with me na jointly. If we get, don't worry. No problem. That much money also you put. You want to write Jairam, you write, no problem. Second, okay. Next is beta, present and past employees are not counted. You know, when I read this point as a student, I had a serious doubt. What is a serious doubt, you know? Yeah, are employees members? If I am working for Reliance, am I the member of Reliance? No. So why is it written in private company present and past employees are not members? In any company they are not members. But beta, sometimes company rewards employees through shares, issues them sweat equity shares. Yes, very good. Issues them ESOP, employee stock option, ESOP, and by ESOP they get the share, get it at less price. So at that time they take shares as an employee, they are rewarded shares as employees. At that time when they take the share, are they shareholders? Are they members? Will they get the rights of members? Yes. They get everything, all the rights, like can they attend AGM, EGM, annual general meeting? Yes. Can they vote in the meeting? Yes. Can they have food in the meeting? Everything they'll get. But while counting the 200, will they be counted? Answer is no. Am I clear with this? Will not be counted. While counting, only for the purpose of counting. Am I clear? Sir, this is about present employees. What do you mean by past employees? Past employee means, beta, as an employee I got sweat equity shares or I got ESOP. I took the shares. After 10 years, I retired. Now I'm an ex-employee. But even now I hold the shares. Will I be shareholder? Will I be member? Yes. But will I be counted in the 200? Make clear. This should properly. And C point. This is not restriction, this is prohibition. No? Prohibition. Prohibits. Oh, I had to change the ink, I forgot. Prohibits. Invitation to public to subscribe securities. To subscribe what? Securities of company. That means a private company cannot invite the public, come, buy my shares, buy my securities. Have you heard about IPO, initial public offer? So private company cannot make IPO. Why? Because it is a private company. That's the third class restriction. In fact, it is a prohibition. It prohibits invitation to public to subscribe securities. That's the reason, beta, the listed companies, shares listed on stock and Reliance, Tata, CS and all, big companies. Okay? Electra, Intelcos, all these companies will be public companies or private companies, beta? Public companies. Because if they are private companies, can they invite the public to subscribe securities? No. And if they are listed, they have already invited the public to subscribe securities. They have done IPO. That is the reason, beta, only public companies can become listed companies. Private companies cannot be listed companies. They are counted as one shareholder. Okay, counted as one. Am I clear? I'll write it here if you. Counted as one. Okay, understood? Clear everyone? Anyone has doubt? Sure. Yeah, I have a doubt. That's the reason. Because my doubt will be professional doubt. Very good. So my doubt comes. Sir, these people are there, na? Present and past employees are not counted. So this point, they are not counted in the 200. Is it in their favor or against them? Graduation, CA, foundation will ask you this thing. State what is private company. Inter final asks you, is this point required? They will ask, test you, are you a professional? Understood? Is it in favor of employees or against them? Against. They are not counted. Correct? No. Answer no, Ray. Will lawmakers make any law which is against any person? No, it is in favor. Now, why it is in favor? See, example, this point is not there. Example, this is not there. Huh? So that means beta present and past employees will also be counted. So example, you all are my employees and total number of my employees is 150. Now I am the person promoter. I have some directors. I take some share. I give to director, their relatives, my wife. So will they be counted? Yes. And they are 50 example. So we are 50. You people are 150. Total is 200. Now if some Mr. X employees joins the company and he does good work for the company and I want to reward him through shares, sweat equity, ESOP, can I reward him? No, because basically my cap is done now. Okay, 200 ka cap is already done. So basically I have to then convert my company into public company. Will any promoter do it? No, because private companies get a lot of exemptions. And that is the reason, in order to always enable a company to reward its employees through shares, present and past employees are not counted. Is it in their favor or against? Favor. Am I clear? There are three things. Not understanding. Understanding law. Next, understanding why the law is made. We do this thing. Then we say we are professionals. If we do understood law, that's the way Google will also tell, na? Why are you required then? Am I clear? Understood? That is public and private. So I'll tell you one interview question which he gave me. Second round, Big Force. He gave me I'll explain. He gave me AO of a company, and this is how they will do for you also. And in that AO, their name is not written. They tell me whether it's a public company or a private company. Now people who don't have any knowledge as they just buy it and become clear inter, see a hook or crook. They try to find the word PVT Ltd, private limited. Then they can say. So basically they turn the pages. What they did intentionally, they on the first page they printed the 3 restrictions. And I told them, sir, it's a private company. Why? Because of the definition. Only one question I was selected. Third round. If you take more than 15 seconds and you turn the pages now, they'll tell you to sit in a room, and this is how they did for me, to sit in a room and tell us whatever your answer is there. The moment you enter the room and read, you are rejected. After 2 minutes, some person will come and say, ma'am, sir is busy, he will give you a call, come on that day. You are rejected. You will not even understand why you are rejected. This is how interviews are taken. Am I clear? Dividend decrease nahi. You are adding na value addition. Yes. Against. Okay. So now Noor Mohammed, understand why it is in favor. Because if this point is not there, then employees would be counted. One day beta, if I issue shares to employees, keep on issuing, one day then limit will be touched 200. After that beta, okay, then I cannot, if any new employee comes and he does good work for the company, can we reward him through shares? No, because the limit of 200 has already been reached. So now beta, I have to convert my company into public company if I want to issue shares to him, if this point is not there. And that's the reason, in order to always enable a company to reward employees through shares, okay, they are not included in that 200. It is just for counting, they are not included. Rest, all the other rights they will be getting. Am I clear? Understood? Yeah. Let's see. Okay. Now I'll tell you one myth which you have, or many people have. Some you'll be shocked to know this thing. I'll give you Bare Act. Bare Act. You might have heard this word like ABC Private Limited in accounts, ABC Limited, Public Limited. I'll give Bare Act. Just find these words, Private Limited and Public Limited, for me. Okay? And ask anything from me. Answer, you will not get these words, because Private Limited and Public Limited, these words don't exist in Companies Act. But sir, we are studying and we see also Private Limited and all. Answer beta, Private Limited and Public Limited is not one word. It is a conjunction of 2 words. Because that is the reason classification is very important. Private Limited means it's a private company with the liability of members limited. So it is Private Limited. Public Limited means it's a public company under section 2 class 17 with the liability of members limited, either by shares or guarantee. It is Public Limited. So we will always, you can always have Private Unlimited and Public Unlimited also. Make clear with this thing. And generally private companies get exemptions from Companies Act. Companies Act is made on the basis of public companies. Private companies get exemptions. So wherever exemption is that, they'll write there. We'll also study. However, nothing in this section shall apply to a private company. They will not write Private Limited or Private Unlimited. Okay? They will not write Private Limited. They will just write nothing will apply to a private company. So it includes Private Limited also, Unlimited also. Am I clear with this? Understood? Clear? Why I am telling you, because on the basis of all this, I am going to draft a question for you people. Okay? So done? Clear everyone? Okay. So now I am giving some questions. Okay. The specific person online you have to answer. Okay. Right, wrong doesn't matter to me, but you have to answer that specific person. I'll explain. I mean, don't worry. Okay. First, let me take the questions. I'll explain you. Don't worry. First question. This question is for Mukesh. Mukesh, only you have to answer. Okay. Mukesh Industries Private Limited can have 201 debenture holders. True, false? A. Prerit, you don't have to answer. Mukesh has to answer. Mukesh, true. Mukesh is telling true. But the limit is 200 na, Mukesh. What do you think, guys? True or false? True. Answer is true. The reason is that beta 200 is on limit is on members. Debenture holders are not members, they are creditors. Okay. Mukesh, you only have to answer. Huh? Similarly, Mukesh Industries Private Limited can issue 201 equity shares. True, false? Mukesh, tell me. False. He is telling false. Why, sir? Limit is 200. Answer is true, Ray. Limit is on number of members, not on number of shares. The company can issue 1 crore shares also to one member, right? So that is the reason. Answer it is true. Do you understand how ICAI will fool? Am I clear, everyone? Okay. Good. Now second question is for Prerit. Okay, Prerit, you answer. Prerit Industries Private Limited can make public issue of debentures of what, beta? Debentures, but not shares. True, false? Prerit, answer. Answer is false. What do you think? True or false? Answer is false. The reason is that beta, okay, a private company cannot make public issue of any securities, not only shares. They cannot make IPO of shares, debentures, bonds, anything. Am I clear with this thing? They cannot make public issue of any damn thing. Okay? Okay, good. Everyone understood? Public company, private company. Anyone has any doubt? Sure. Great. क्या बात है? Wow, 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 wow. I'm very happy. Law is very simple, right? Very simple. Or if you understand the concepts now, you'll see the paper and laugh what time pass paper they are giving, because we'll take examples at this level, very tough level. Paper level is very less, like it is very low level. You'll easily crack the questions. Now, okay. Now understand, pay the attention on this. Coming to private companies. Understand, guys, private companies are there. Na? In Companies Act 1956, there was only two bifurcation. Public company, private company. There was no further bifurcation of private company. But now private companies have been further bifurcated into two parts. Further bifurcated as small company and one person company. As what, beta? Small company, one person company. What do you mean by small company? So further, first we'll understand why this bifurcation is done also, made also. The purpose of bifurcation is to grant exemptions. Like, I'll give you example. Reliance Industries Limited. There is one company with a turnover of lakhs of crores. And there is one company, Harsh Industries Private Limited. Turnover of 15 lakhs. Reliance 15 lakh crore. Tell me, rules and regulations applicable for Reliance should be equally applicable for Harsh. Which company should get exemption? Harsh. Because Reliance can always anytime appoint a chartered accountant, give him 25 lakhs ka package and tell do the compliances, boss. But can Harsh do it? Arey bhai, their turnover is 15 lakhs. CS salary will be carried forward every year, payable. Yes or no? And that's the reason for purpose of granting exemptions. private companies are classified, okay, as what? Two parts: small company and one person company. Small company and one person company. One person company is a beautiful topic. Now small company, sir, what exemptions they get? I'll give you, like, normal companies have to take 4 board meetings in a year. Conduct. These companies have to conduct only 2 board meetings. In one person company, if he is the member and the director, only one director, then why to take board meeting also? In fact, annual general meetings also they don't have to take. He is the only, what will he do if he is the member and director? Not required. Then very important, all companies have to prepare financial statements. You know what is financial statement? If I ask you what is financial statement, what is your answer? There are 5 things: P&L, balance sheet. Understand, online people? P&L, balance sheet, cash flow statement, notes to accounts, and statement of changes in equity. We'll understand properly in lesson number 9 also, don't worry. What? P&L, balance sheet, financial statement, sorry, cash flow statement, notes to account, and statement of changes in equity. All companies have to prepare. But these companies, small company, OPC, they are exempted from preparing cash flow statement. So their financial statements can be completed without cash flow statement. Am I clear with this thing? OPC also. Then have you heard about corporate social responsibility? Companies have to donate some money, okay, towards CSR, corporate social responsibilities activities, which I'll teach you. But these companies exempted, small company, not required. Am I clear with this thing? Understood? So basically there are a lot of exemptions. These are just few I told, but there are a lot of exemptions which these companies get. Am I clear? Then their annual returns and other documents. Other companies have, their documents have to be signed by more than one person. This only one person has to sign. Okay, so many exemptions are there. Okay, we'll study all those exemptions. And for these exemptions only, private companies are classified as small company and one person company. Now what is small company? Understand, section 2 clause 85. Sir, small company means this much company, ground floor? No, Ray. Small doesn't mean in terms of size, it means in terms of capital and turnover. So small company, Achha, I'll ask you one question, you'll give me wrong answer. Challenge. Online students also, quickly you have to answer. Okay. Small company means a company with a paid up capital, as of 31st March, year ending, with a paid up capital up to rupees 4 crores. How much, beta? 4 crore. And turnover. What I am writing, beta? Turnover up to rupees 40 crore as of 31st March. So small company means a company with a paid up capital up to 4 crore and turnover up to 40 crore. And so you should be within the limits, both the limits. If you are within both the limits, beta, you are considered as a small company. If you cross any of the limit, you are a normal private company. So whatever exemption small company is getting, you will not get. Am I clear with this? But now students get confused because of this definition. You know why? Because the definition is given in a very different way. What is written now? Small company means a company with a paid up capital, okay, up to 4 crore, which may be increased. Up to 10 crores. Up to how much, beta? 10 crores. And turnover up to 40 crore, which may be increased. Up to 100 crores. How much? 100 crores. So, sir, currently limit is 4 and 40 or 10 and 100? Answer, it is 4 and 40 only. So what is this 10 and 100? Beta, 10 and 100 means in case central government, what, beta? Central government wants to increase this limit from 4 because of inflation and all. From 4 to 10 they can make it, 4, 5, 6, 7, 8, 9, 10, up to 10 they can do by notification, central government. 40 to 100 also they can do by notification. But if 10 and 100 has to be increased, then central government cannot do it. Then you have to go to the parliament. How law is made, na? I told you yesterday. Take a bill, company's amendment bill you have to draft. Then beta it will go to the parliament. Then beta president's consent will come. Then by company's amendment act, maybe 26, 25, you have to do it like that. So parliament can do it. Central government cannot do it. Am I clear with this? Understood? Clear everyone? Yes. So currently limit is 4 and 40. Clear everyone? Yes. Okay. Now I'll write a name of a company. You tell me whether it's a small company or not. Okay. Mini Industries Limited. Mini. Paid up quickly. You have to tell na everyone. Paid up capital rupees 3 crore. Turnover rupees 39 crores. Is it a small company? Yes or no? Yes or no? Quickly. Yes or no? Yes or no? Yes or no? Yes or no? Answer is no. Because it is not a small company, Ray. Sir, but it is within the limit, na? Arey, because it is Mini Industries Limited. It's a public company or a private company? Public company. Small company is a type of private company, Ray. Came in this madam. Oh. See what question I draft. They see ICAI asks. Fair. I think in your lecture also I told this thing. This Mini Industries Limited I took. Why didn't you attend? Okay. Very good. Yes. See, many people are writing yes, yes, yes. Okay. No, it is not a. It is a public company. That is the reason. Okay. Clear, everyone? Understood? But see. But what is? How is this definition given? A rough part I am explaining. For the timing, a bit rough part. Okay. See. What is written? Nothing in this section shall apply to. That means if you are falling under these categories, then beta you will not be considered as a small company even though you are within the limits. Which? A, holding and subsidiary company. Holding and subsidiary company. So sir, what is holding and subsidiary company? I'll tell you rough explanation. I'm giving you rough. Don't consider this absolute. A rough explanation. Understand? See, holding company means papa company. Subsidiary means bacha company. Okay, son, daughter. Like A Limited is there, B Limited is there. If A Limited holds majority of shares, rough explanation. A Limited holds majority of shares of B Limited. Then A Limited is the holding and B Limited is the subsidiary. Am I clear with this thing? If your company is a holding company of another company or subsidiary of another company, then beta it is not considered as a small company. That means in order to be called as a small company, you should not be a papa, you should not be a bacha, you should not have family, you should be orphan. Am I clear with this thing? Next. Second, Section 8 company. What do you mean by Section 8 company? Non-profit company. Sir, if you are a section non-profit company, companies form not for profit, registered as non-profit company, that means Section 8 company. So you will not be called a small company. You know why? The purpose of telling a company or drafting a company as a small company is to give exemptions. Section 8 company gets lot of exemptions under Section 8, more than what Section 2 clause 85 gives. So basically, you cannot get Section 8 exemptions also and Section 2 clause 85 exemptions also. You cannot take both the exemption. So you cannot be both. You can either be a small company or a Section 8 company. Can you be both? Like we say, na, you can be either happy or you can be married. Can you be both? No. Am I clear with this thing? Understood? I'm happily married. This is just for lectures. Next. Achha, you should give an example of this. Company regulated under a different act. Online students, give me example. Tell me, example, I told you, example of this, company regulated under a different act. LIC, I knew, Sashidhar, you will tell this. Arey, LIC is not a company, it is a corporation. I have written company regulated under a different act. Banking companies, ICICI Bank, Max Life Insurance Company, Reliance Industries Limited, sorry, Reliance Energy Limited. All these are companies formed under Companies Act but regulated under a different act. Did you understand? Okay, sir, why don't we categorize them as a small company? See, small companies for purpose of giving exemption. Arey, for them, the whole Companies Act is exempted. They follow their own law. So, why will we categorize it as a small? Am I clear with this? Understood? See, many people wrote LIC. But I exactly know what you will write. Understood, everyone? Okay, so if you are a holding or a subsidiary company or a section 8 company or your company regulated under different act, will you be categorized as a small company? Clear? Okay, so I'll show you one question, exam question, direct exam from the paper. Okay, you have 2 minutes to answer. Online students also. Okay, please answer. Can you see question or should I zoom? Now, somewhere fine. Oh, I can zoom it more, I think. Now it's fine. See the question. So I'll read the question. The information extracted from audited financial statement of Smart Solution Private Limited as at 31st March 2020 is as below. Paid up equity share capital 50 lakhs divided into 5 lakh equity shares of 10 each. There is no change in the paid up share capital thereafter. The turnover is 2 crore rupees. It is further understood that Nice Software Limited, which is a public limited company, is holding 2 lakh equity shares fully paid up of Smart Solutions Private Limited. Smart Solutions Private Limited has filed its financial statement for the said year with the Register of Companies excluding cash flow statement within the prescribed timeline during the financial year 2021. The ROC has issued a notice to Smart Solutions Private Limited as it has failed to file cash flow statement along with balance sheet and P&L. You are to advise on the following points. First, whether Smart Solutions Private Limited shall be deemed to be a small company whose significant equity shares are held by a public company. Second, whether Smart Solutions Private Limited has defaulted in filing financial statement. Okay, so I'll show you the question. I'll scroll it. If you want to tell me to scroll, I'll scroll it. Now, how to solve questions? Now, I always tell this thing. Whenever the statement comes in your rough book, just make diagrams. A Nice Software Limited, arrow, take a paid up capital this much and all. Smart Solution. When you make the diagrams, take a automatically answer will come. Start. Huh? Limit majority of shares. If A Limited holds majority of shares, then A is holding B is subset. Okay. Holding company and subsidiary are not small company. Akshay, you are asking or telling? I didn't understand. Telling. They are giving the answer. Okay. Everyone solved? Hmm. Mhm. Answer first. Whether smart solution brand shall be deemed to be a small company. See, whether it is a small company. First, what is given the information? Smart Solutions Private Limited. है ना? Like how many, what is the paid up capital? 50 lakhs divided into 5 lakh shares. And turnover is 2 crores. So is it within the limit of small company? Yes, 4 crore, 40 crore. Achha, out of these 5 lakh shares, Nice Software Limited is holding how many shares beta? 2 lakh shares. 2 lakh shares are held by Nice Software Limited. So how much percentage? 40%. Yes or no? So is it a small company? Answer is yes. Because beta, if you, when will you not be a small company? If you are a holding or subsidiary, it is not subsidiary. For subsidiary, majority of shares should be held. So it is a small company. The first question is all solved by us. It is a small company. Yes. Second, whether Smart Solution Private Limited is defaulted in filing financial statement. The question tells that they have not filed cash flow statement. So ROC has issued notice. Is it required to file cash flow statement? No, it is not required to prepare. It is exempted, I told you. Okay. So basically, answer is no. Am I clear? So it's a accumulation of two sections. One is section 2 clause 85 and one is section 129, which I'll teach you in lesson number 9, that exemption wala point. Am I clear? Understood? Clear? Okay. So if you have solved this question, how many marks you have fetched? 6 marks. So this is exam paper. Directly from the paper I showed you. So this is how paper will come. If you know the concepts properly, you will solve the paper like this. But if you don't know the concept, even if I keep the bare act in front of you, the whole module, you will not be able to understand what he is asking. I hope I'm clear. Everyone? Yes? Okay. Yeah. So that's it for the day. Okay. We'll do it. Aman, first thing in the morning. Sorry, not in the morning. Tomorrow we'll do it. Okay. Your doubt I'll solve. Don't worry. First thing. Then we'll start the lecture. Okay. That's it. I hope you understood everything. Yes. Signing off. Bye bye. Take care. Bye. Bye. I have not disabled Navya. In fact, I don't know how to disable also. I'm very bad in this. I'll check it. Okay. Don't worry.